2. Alrighty, well, good afternoon, everybody. Thank you again for making a trip through the rain and the women's restroom to join us here today in the Bartlett room. Before we begin, I'd like to ask you to please silence all cell phones, any mobile devices. Are you going to? You're going to do that right now? Very good. I probably need to do that too when I sit down. And I want to invite all of you to pick up some materials which are over on the table. There's some booklets from the American Bar Association and then biographies of each of our panelists today. And it doesn't look like we have the same problem that we did last time, but we have an overflow room which is streaming our video, and that's down the hall in 268. I now want to introduce to you, give you a longer introduction than last time, though not much. I did not write a treatise on him. I want to introduce you to Keith Bybee, the director of IJPM. He is also the director of the Sawyer Law and Politics program in the Maxwell School, which is one of our co-sponsors for today's event. And when he is not directing institutes, he's teaching. He's the Michael O. Sawyer Chair in Constitutional Law and Politics. Keith, good afternoon.
Thanks, Bert. The first thing I want to point out is that this microphone here is not actually amplifying my voice, which may have been obvious to you in the room. However, it's part of the videotaping that we have going on here. So it's not a question of me standing closer to the microphone or further from the microphone. If you can't hear from me, I'll try to speak up. So I assume everyone can hear me. Welcome. Today's event is entitled The Last Umpires, ? News Media, the American Bar Association, and Other Independent Voices in the Federal Judicial Confirmation Process. As Bert mentioned, this is a jointly sponsored event by the Institute for the Study of Judiciary, Politics, and the Media at Syracuse University and the Sawyer Law and Politics program at the Maxwell School. 1 year ago today, if you cast your mind back, the United States was in the middle of what turned out to be a pretty long season of appointments to the Supreme Court. John Roberts had been confirmed as the new Chief Justice of the United States. Harriet Miers had been nominated to fill Sandra Day O'Connor's seat. By the end of October, she had withdrawn her nomination. Samuel Alito was subsequently nominated in her place and ultimately confirmed. Now, while this process was going on, it became pretty clear that it was thought about, at least by the general public, in political terms. In fact, in October of last year, the Institute for the Study of Judiciary, Politics, and the Media, or IJPM, as we call ourselves, commissioned a nationwide survey on public opinion about the courts. And one of the questions we asked was whether people trusted the president, Republican president, and Republican Congress to pick good federal judges. And we found that Republican respondents to the poll were 8 times more likely than Democrats to trust the president and Congress to pick good judges. There's clearly a strong public view that this process was political, that it was filled with, perhaps entirely consumed by, partisan considerations. Now, we can grant that and still wonder, is there anything more to the process, or is this all there is to the process? In part because the conventional view of judges does not see them as partisan. The conventional view of judges and judging sees them as impartial actors who make decisions based on the facts and law of the case before them. Now, this conventional view may be wrong, but the conventional view is nonetheless that judges are not representatives of a particular party's position or a partisan point of view, that if they represent anything, they're supposed to represent the law. So this kind of conventional view, set alongside a political view of the process, leads us to ask some questions that are at the heart of the discussion today. Those questions are, is there or can there be an independent, nonpartisan voice in the federal judicial confirmation process? Has there ever been such a set of voices? If so, who are they? What role have they played? Has this role changed over time? Are there independent, nonpartisan voices out there somewhere that should be involved in the confirmation process and are not? These, among many other questions related to politics and impartiality in the confirmation process, are ones that we will explore today with the help of our three distinguished panelists and also with the help of our audience during question and answer. To help guide us to introduce our panelists and also to serve as moderator today, we're fortunate enough to have Lisa Dolak, who is a professor of law at the College of Law here at Syracuse. Lisa is also Senior Associate Dean for Academic Affairs. She's Associate Director of Center on Property, Citizenship, and Social Entrepreneurism, and she's also Associate Director of IJPM. Lisa has published widely on judicial procedure, patent law, and legal ethics, and the intersection thereof. She also has had firsthand experience with the federal courts, not as a party to a suit, but as first clerk for the Honorable Paul F. Michel, who's now Chief Judge of the United States Court of Appeals for the Federal Circuit. And Lisa also currently serves as a member of the Federal Circuit's Advisory Council. So she's well suited to conduct and moderate a discussion of the federal judicial confirmation process. So please join me in welcoming Lisa Dolak.
I was wondering what you said in several ways. I've had experience in several ways, and then you mentioned the clerkship, and I couldn't, for the life of me, imagine what the second way was. But that's right, the Advisory Council of the Court. Thank you for coming, and welcome to our program. I hope you'll find it to be, and I believe you'll find it to be, a very interesting and enlightening program. As Keith said, we're here to talk about a number of questions, the questions that he mentioned and some others that I'll ask our panelists to ask one another, and then ultimately we'll ask the audience to get involved in the discussion as well. In terms of format, I'll introduce each of our panelists in turn and ask them to give us a brief initial take, 10 minutes or so, on the general subjects that Keith outlined for us. And then we'll have about an hour, maybe a little less, for a panel discussion that I will moderate, and then we'll turn it over. We'll open it up to the audience for questions and comments for the last, certainly at least 20 minutes or so of the program. So please stay and be thinking of the things that you would like to ask the panel. That's our format. Just to begin, I'd like to share the perspective of one scholar who's not on the panel, but who has offered some thoughts in support of participation by independent voices. And I thought this was an interesting quote from an article that this person has written, and I would ask you to think about the potential benefits. Start by thinking about the potential benefits of participation by independent voices, if there are any, before we hear the views and comments of our panel of experts. Particularly in a time of divided government, which has haunted us in the recent past and may well continue for the foreseeable future, the work of a third party, even a third party sometimes viewed as allied with one political party or another, can help to avoid stalemates, disingenuous presidential assurances about avoiding litmus tests, and inquiries into nominees' ideology, and other possible shams. Not only is this extra voice consistent with the Constitution's confirmation structure, but it also reinforces public confidence in impartiality in our courts. Balanced, unbiased justice more likely emerges through a checks and balances process, with actors possessing competing perspectives. In such a system, the public more readily believes that good things happen to people, such as receiving a federal judicial nomination, because they have successfully navigated the scrutiny of diverse and sometimes hostile actors, rather than simply because some insider wired them for the job. So with that sort of as background, I'm going to turn the program over to our panelists. Beginning, I will introduce each of our panelists one by one and invite each to make some opening remarks. We're going to begin with Professor Lee Epstein, who is the Beatrice Kuhn Professor of Law at Northwestern University School of Law. She is also a Fellow of the American Academy of Arts and Sciences and the American Academy of Political and Social Science, a recipient of 10 grants from the National Science Foundation for her work on judicial politics. She has also authored, co-authored, or edited over 70 articles and essays and 14 books. She is currently working with the papers of Justice Harry Blackmun for a book on agenda setting in the on the U.S. Supreme Court. I have a copy of one of her books entitled Advice and Consent, The Politics of Judicial Appointments. And I just want to share with you, if I may, the opening sentence, which says, of all the difficult choices confronting societies when they go about designing their legal systems, among the most controversial are those pertaining to judicial selection and retention. I thought that was a very interesting way to begin the book and hadn't really thought about this as being, this subject that we're here today to talk about, judicial selection and retention, as being among the most controversial in terms of designing a legal system. But I will turn over the podium now, or the microphone. Well, you're going to come up here and give your remarks, I assume. Or are you going to?
I can sit.
Okay, that's fine. Thank you very much. Professor Lee Epstein.
Thanks. I guess I want to start off by reiterating and emphasizing something that Keith said, which is that the appointment of federal judges is now and always has been a political process, that it has been dominated by ideological and partisan concerns. And that is true in the 1800s as it is in the 2000s. And I think, contrary to the quote that you just read, but I think the reason why the process has been so dominated by politics is because the judges and justices themselves are political. I mean, Justice Scalia is not Justice Stevens. Justices are not fungible. They come to the court, especially the Supreme Court, I think, with ideological commitments, partisan commitments, and they infiltrate their decisions. Again, contrary to the quote you just read. So it does matter. And for these reasons, this ideology and partisanship tends to play out in the process. And as I say, it always has. This is not to say, I think, that the process isn't in some ways very different now than it certainly was in the 1800s. Most relevant to the symposium today is that there are a lot more players in the process now in the 2000s than certainly going back even to the 1900s. You know, think about the role of the media. Richard Davis, a political scientist, has a new book out called Electing Justice. It's a very interesting book. And it deals primarily with the increase in media attention to federal judges and especially Supreme Court justices' appointments. He documents a huge sort of exponential growth in media coverage since the 1800s, and even actually since 1987 with the Bork nomination. I think he shows that New York Times coverage of Supreme Court nominations since Bork, so 20 years, has increased by about 40%. Popular magazines like Time magazine, their coverage has increased like 300%. It's giant, more attention to these appointments. For Davis, this is a really bad thing. You know, the media has created a circus out of federal judicial appointments. And, you know, maybe some of you agree with that it's now, you know, this political circus when it should be sort of this dignified process. Just for a few minutes, I want to take the opposing position. I want to argue that the media has played an extremely useful role in the nominations process. Why? Certainly not because I think the media, the press, is objective. Especially if you obviously looking at newspaper editorials on these nominations. You certainly don't see a lot of objectivity. Here I've got the Wall Street Journal's take on Justice Alito. One of the quotes, the top quote, was right after Alito was nominated, and the bottom quote around the times of the hearings. I like that bottom quote. We're confident Judge Alito won't join the court's liberal wing. This is the Wall Street Journal speaking, no surprise. Contrast the New York Times. editorials written, you know, roughly around the same time. I mean, the Times was so, you know, upset about Alito that they actually advocated a filibuster. It says here, a filibuster is a radical tool, but from our perspective, there are some things far more frightening. One of them is Samuel Alito on the Supreme Court. Very, obviously, very different takes on these nominees. But if you look at them long enough, you will see a point of agreement. Wall Street Journal, New York Times, point of agreement that Samuel Alito is conservative. They may disagree about whether it should be on the court or not, but they're providing some information. And it turns out that they're actually providing some really useful information. It's not that they're just tagging Alito as a conservative, but actually the tags that these newspapers give Supreme Court nominees are quite predictive of their behavior once they're on the court. We learned this when we were doing the advice and consent book. We looked at newspaper editorials printed in 4 major newspapers, 2 liberal, 2 conservative. We analyzed those editorials, and for each nominee to the Supreme Court going back to 1937, we were able sort of to give them a score. Very, very liberal, very conservative, somewhere in between. And I'll put something up, you can take a look at these for yourself. This is just solely based on what the newspaper editors said about the nominees when they were nominated. I don't know if you can see this. You see at the top, just the people you would expect to see at the top in terms of conservatives. You see Scalia and Rehnquist, Bork, Alito. Looking at the bottom on the very liberal end here, you see the Brennans, the Fordices, the Marshalls. These were how the newspapers characterized these nominees at the time of appointment. They really kind of square with their own intuitions about these people. What's remarkable is that if you take these characterizations of the newspaper editorials and you compare them to the justices voting, at least in their first 10 years, the association's like 0.8. You know, meaning that these initial characterizations that the press is giving us about these nominees are quite predictive of how these people are going to, how these justices are going to behave once on the court. It's quite extraordinary. Now, so it sort of brings me to this point of there's a lot of people out there who bash the press right now about the way they cover nominations. But I think just even this little demonstration shows the kind of useful information that the press can provide, actually predictive information about how these nominees are going to behave. And it strikes me that this is a good thing. More information is better, especially when it's reasonably accurate information, to let the public make some decisions about these nominees. Now, and I also think the kind of heated discussions that these sorts of press coverage, newspaper editorials, blogs now are generating, the kinds of discussions Americans have when a Samuel Alito is nominated, when a Roberts is nominated. They're very healthy. I mean, it's the one time I see just Americans, my students, everybody out there talking about federalism, privacy, you know, equal protection. When Alito was, his nomination was before the Senate Judiciary Committee, my 7-year-old mother called me and said, "What's all this about the Commerce Clause?" You know, that people out there are engaged, and the media is helping to fuel kind of a discussion about critical constitutional issues. I don't think that's a bad thing. So that's kind of my take.
Thank you very much, Professor Epstein. Thank you. Our next presenter and panelist is Mr. Steve Tober. He is the former immediate past chair of the American Bar Association Standing Committee on the Federal Judiciary, which is the committee of the American Bar Association that rates judicial nominees. He practices in New Hampshire. He's been active in state and national bar leadership, including the New Hampshire Bar Association, the New Hampshire Trial Lawyers Association, and the Association of Trial Lawyers of America. He has twice received the New Hampshire Bar Association's President's Distinguished Service Award. He served as a member of New Hampshire Supreme Court's Board of Bar Examiners. He's a fellow of the International Academy of Trial Lawyers, the American Bar Foundation, and the New Hampshire Bar Foundation, and he is a most distinguished graduate of the Syracuse University College of Law. So we're delighted to have him back on campus with us today, and very proud to call him one of our own.
Proud to be called one of your own. Before I make my remarks, I would be remiss if I did not acknowledge the presence of Judge Joanne Alper in the audience today, a new member of the Board of Trustees of the university, and more importantly, we went to school together here. Of course, she was 9 at the time, and I won't argue with that. She is, however, prepared to rule on any objections to my remarks, so I'll try to make sure I don't stray too far. Mine is a very different role to be here to talk about. I feel a little bit like the person who went to the wrong dance and had to stay, notwithstanding the dance. The American Bar Association has a very long history of being involved in the evaluation of all federal nominees to the bench. It has been doing so consistently since 1948, when it first started advising the Senate Judiciary Committee regarding all nominations. In 1952, President Eisenhower invited the American Bar Association into the process, and as a result of that, we started advising the president of all nominations, and 2 years later, in 1956 or 55, we of course issued a rating on then California Governor Earl Warren to be Chief Justice, and we've been going at it ever since. The way the committee has worked has historically been one, up to 2001, of pre-nomination screening, pre-nomination evaluation of potential nominees. A call would come in to the chair from either the White House or the Department of Justice with name or names of individuals being considered by the president, and sometimes with as little as 24 hours to respond. Professional qualifications would be considered and reported back to the president. Sometimes the president would go forward, sometimes the president would not. That process changed in 2001, in March of 2001, when the President administration decided to stop presenting names pre-nomination and presents names now only post-nomination, so that the chair receives the information from the Department of Justice. At the same time, the Senate receives the information from the Department of Justice, and the process goes forward from there. A couple of background points I'd like to make that might explain a little more what we do. And I brought some material that I urge you to take a look at when you have a moment. We have the blue pamphlet called Our Backgrounder, which is in fact this item right here that explains in very good detail what this Bar Association does, the Standing Committee does for the American people. I've also brought our 20 or 25 page letter of explanation when we did the evaluation of Samuel A. Alito Jr. to be Associate Justice, and I think that gives you some insight into the process as well. The American Bar Association, to put this in some perspective, I'm not sure everybody in this room would know, is the largest professional association in the world. It has over 400,000 lawyers and judges belonging nationally. And I bring that up because I want to set the perspective on this committee. I believe that the American Bar Standing Committee is the flagship committee of the American Bar Association. We have very secure firewalls that we put up so that the leadership of the American Bar Association, the national officers, the Board of Governors, the House of Delegates, the policies that are determined by those folks have no bearing whatsoever on the work and product of the Standing Committee on Federal Judiciary. It is a very separate, very discrete group. It is absolutely true that the president of the ABA finds out what the ratings are of any federal nominees at the same time the American public does. There is no breach of that firewall. The committee itself consists of 15 very distinguished lawyers who are appointed because of their standing in their respective legal communities in all of the federal circuits in this country. The last year in which I got to chair, the 14 people I got to work with were an extraordinary group of individuals, highly diverse by way of background, practice, location. It was an incredible experience, just a plethora of riches of talent and of judgment and of understanding that came onto that committee and evaluated nonstop from August to January John Roberts, Harriet Miers, and Samuel A. Alito, Jr. We, in fact, were working on an evaluation of Harriet Miers. As I've told others, we were pretty much in the 7th inning when the game ended. I was prepared to go interview her on a Sunday in, I believe it was October, when the Thursday before she announced her withdrawal. What that tells you is that we had done a significant amount of work in the field, interviewing colleagues, lawyers, others, non-lawyers who would have known the nominee, and we had done reading of all of her writings, but it stopped. So there is no letter of explanation for Harriet Miers. There is one for John Roberts and for Samuel Alito. The process has been going on for almost 60 years, and it adheres to very objective, well-articulated standards of what we do. And herein is the rub for why I say I feel like the wrong person at the dance. We look at integrity, we look at professional competence, and we look at judicial temperament. We do not do politics. We don't look at partisan activity or partisan concerns. We don't look at ideology. That is, in fact, the truth and the guardrails of how this committee works. And so there were many times in the last 12 months that I got to chair this committee that I felt a bit like Diogenes walking through a world that was completely foreign to me. I am looking for the honest person on a landscape that I did not understand, because the landscape is highly charged political landscape. And here I am saying, well, here's the honest person, here's our rating, and they would say, thank you for that, now we go off and do what we have to do. I think this seminar, this opportunity is to talk about how effective is that. And I look forward to the opportunity to talk about that, because I believe what the American Bar Association does is absolutely critical to the well-being of the independence of the judiciary in this country. We work hard on behalf of the American people to assure that the most qualified and the best folks are getting on the federal bench. When we have to issue a not qualified rating, it's not pleasant, but we've done it. I should, as an aside, point out that since this administration took office in 2001, I believe we've done, well, I've lost track of the numbers, but we've done a significant number of evaluations. I was on the committee as the First Circuit representative for 3 years. During that time, I voted on over 250 federal nominations to the bench. Last year, as chair, we had 51, so I've personally witnessed over 300 nominations, including 3 to the U.S. Supreme Court. It is a remarkable effort, and 98% of the ratings we've given to the White House are either well-qualified or qualified. That comes down to a 2% factor of those folks that we feel, as a committee, were not qualified to serve on the basis of either integrity or professional competence or judicial temperament or a combination of the above. It is not a political judgment that we make. I'm pleased to be here because this is, in fact, an opportunity to explain the peer review that we do. There may be other umpires in the game. I'm not sure what all that means. Umpires have the final word. I'm not an umpire. But we are the only ones who can say that we do a peer review. When we speak, when the American Bar Association Standing Committee on Federal Judiciary speaks with respect to an evaluation, it speaks on behalf of the bench and bar of this nation. And while you can have other subsets doing that kind of work as well, and you do, there is no other uniform group with the resources, with the ability to put people on the ground in the field that the American Bar Association has. I do offer up this. When you have a chance to take a look at our backgrounder, on page 11, at the very end, in the conclusion, it says this: the committee constantly seeks to learn from its experiences and to refine and improve its standard procedures. To this end, the committee welcomes suggestions from members of the bar and the public. And indeed, we do, and I look forward to hearing some of them today. Thank you.
You may not get the final word, but you have to call it a ball or a strike, right?
I guess.
Or very much a ball, or just a ball. Our third speaker is Lyle Denniston. He is now in his 58th year as a journalist, his 48th year of covering the Supreme Court. He has covered, think about this, he has covered one of every 4 justices ever to sit on the Supreme Court. So I think he has some relevant knowledge for us today. He retired from the Baltimore Sun in February of 2001 after covering the court for the Sun for 19 years. He then covered the court for the Boston Globe for 3 years and had previously covered the court for the Washington Star and the Wall Street Journal. His main journalistic activity now is covering the court for an internet-based clearinghouse of information about the Supreme Court's work known as SCOTUS blog. He reports on the court for radio station WBUR, which is an NPR affiliate in Boston. He has taught at the undergraduate level and in law schools. He is currently serving as an adjunct professor of law for the Massachusetts School of Law in Andover and received an honorary Doctor of Laws degree from that law school in 2002. In addition to his reporting, he is an active freelance writer and is the author of a standard manual used in newsrooms and in academic journalism throughout the nation titled The Reporter and the Law, Techniques of Covering the Court. And we thank you for being with us today.
Thank you, Lisa. It's always a real treat to be in the presence of the Holy Trinity. Here it happens to be the judiciary, the political realm, and the media, but still a very holy group, and I'm delighted to be associated with it. Because I am a journalist in the conventional behavior of journalists, I'm here to bring you bad news. The American Bar Association's Committee on the Judiciary is wonderfully distinguished, but it is irrelevant. The American media performs a magnificent role, but it is irrelevant in this one realm that we're talking about here. The Senate Judiciary Committee is, by my estimate, the most political committee that sits in Congress. It is a committee that is now in total enthrallment to the outside interest groups, not the American Bar Association, not the media. The committee has developed a capacity to co-opt virtually every independent voice, virtually every outside umpire that would approach the committee during the confirmation process. The committee, by the way, is one of the least representative of public institutions that you can imagine. It has 18 members, and the states that these 18 members now on the committee represent constitute some 20 million Americans. That is about 11 to 12% of our population. And that tells you a number of things, but among other things, it tells you that many of these representatives, these senators, come from constituencies that are peculiarly susceptible to the kind of base-oriented politics that American politics has become. In smaller states, it is a whole lot easier for Karl Rove to engineer a base-oriented operation that produces the kind of members of the Senate Judiciary Committee as Tom Coburn of Oklahoma, who, by the way, distinguished himself during the Alito hearings by telling the judge that he was really most impressed by the judge's body language. Tom Coburn practices medicine, but I hope not outside the field of veterinary medicine. It's a committee that represents the smallest of states. The balance of power in that committee is held by senators who represent collectively, all 18 members collectively represent enough people that would constitute the 20th ranked state in the Union in terms of size. So what that tells you, among other things, is that the future of the American federal judiciary is being determined by an institution that is not now, nor has it ever been, truly representative. But that's not the cardinal vice, the primary problem with the Senate Judiciary Committee. It is that the committee has, in recent years, lost, virtually totally lost, the capacity to exercise an independent judgment. It is now the tool of people like Nan Aaron, Ralph Neese, Paul Weyrich, Boyden Gray, and if you've covered or hung around or monitored any of the contemporary Senate Judiciary Committee hearings into nominations, including Supreme Court nominations, the four people whose names I have given you are the main players in the process. What Boyden Gray and Paul Weyrich say to the Republican members dictates how the Republican members behave. What Nan Aaron and Ralph Neese say to the Democratic members dictates what those members say. The American media, so far as it has continued to pay attention to the process, and Lee has told you that it's paying increasing attention, has become essentially the deliverer of information generated by these outside interest groups. It's a habit now among all of the media that cover the nomination process, once a nomination has emerged from the selection process at the White House and then the participation of the American Bar Committee, to go in deeply into the background. There is one instinct that drives the American press's inquiry into that background. It is, how can we tell whether or not this nomination will succeed or not? It is distinctly a journalistic endeavor that is oriented entirely to the bottom line. Will the nominee win or will the nominee not win? There is only secondary interest in the process itself. There is very little interest in the substance of law that is being discussed in the committee. And in fact, the press has no more interest in the substance of law than do the members themselves. Because legal substance, when it is used in this committee, is used either as a weapon of support or of opposition to the nominee. And if you've watched any of the contemporary hearings in the last, say, dozen nominations, you see the process in all of its inglorious character. A committee member on one side will ask a question designed to elicit either a favorable or an unfavorable response, depending upon the partisan affiliation of the president who nominated that nominee. Then, if that question elicits an answer, perhaps an embarrassing answer or one that may suggest the possibility of becoming embarrassing, then the turn comes for a senator on the other side to try to rehabilitate the nominee. It goes on in that process, all of which is oriented towards trying to defeat the nominee or to get the nominee to succeed. Now, if this is an inquiry into comparative merit of judicial nominees, it is the strangest kind of inquiry that one can behold. The press's role, which is the one about which I know the most, and which I have been a part of for the last 50 years, 50 plus years, is a role of not being independent of the process. The press is very much a part of the process. And I can't tell you how many times during the Roberts and Alito nominations that I fended off attempts by Nan Aaron or Ralph Neese or Boyden Gray or others to get stuff on our blog, not in order to advance the public conversation, not to enlarge the nature of the public inquiry, but to score points. Score points toward that bottom line of whether the nominee is going to succeed or fail. And the nominees, by the way, in the process, become unwitting participants in the debasing of the process. When a nominee like John Roberts repeatedly insists that I am not going to respond to your questions in order to get your vote. He is already contributing to the process, because if it were a serious inquiry, if John Roberts did take it as seriously as he ought to have taken it, he would respond as best he could in the interest of advancing the public conversation. The same thing happened with Samuel Alito. Samuel Alito, by the way, I observed him making a public speech this summer, and Samuel Alito is still deeply bruised by what happened to him during the nominating process. He got up to make a public speech in a judicial forum, and his first anecdote was how his sister had gone hiking in the summer in Outer Mongolia. And the point of the story about her having gone hiking in Outer Mongolia was that at one point she was chased by a pack of wild dogs, which caused her to hurry back to her tent for refuge and safety. Justice Alito then says, that is what has been happening to me for the last year. Now, do you think that Samuel Alito has come out of that process believing in it as a good democratic inquiry into his merits? Do you believe that he thinks the process was, in fact, working the way it perhaps ought to work? He came away from it very much the same way that Clarence Thomas did, by being wounded by it. And we all nationally saw what was happening within the little community of the Alito family when Mrs. Alito rose and left the committee room in tears because of what she took to be the abuse that her husband was being required to undergo. So that's the sad tale. That's the downside of the process as it exists. It would be absolutely wonderful if the really sound fundamental inquiries that the American Bar Association's committee makes into questions of competence were decisive. They are not. It's fortunate that the process itself coughs up nominees who are as good as the ones have come to be, but it is not a predictable part of the process. In fact, we came so close last summer to having a person on the Supreme Court who was riotously unqualified for the Supreme Court. And I'm referring, of course, to Harriet Miers. Harriet Miers was, or would have been, the weakest member of the Supreme Court since perhaps Franklin Pierce was as president. She would have been as weak as any of Harry Truman's cronies that he put on, people like Harold Burton, who distinguished themselves by producing no distinguished work. She would have been as weak as Charles Evans Whitaker, who resigned from the court after 5 years because he could not handle the task of judging. That is how close the process, as it now exists, came to what, in fact, would have been a monumental disaster. However much you may respect the Supreme Court of the United States, it is not a strong enough institution to have rescued Harriet Miers from historical obscurity, embarrassment, and shame. Beyond that, I won't have much to say.
Well, it looks like I've got a pretty easy job. I think I can just perhaps wind up the panel and let them go. But thank you very much for those very thought-provoking opening remarks. I'd like to start where we began, which is this notion of independent voices. Lyle, you said the ABA's voice is irrelevant, but you didn't seem to me to be questioning its independence. Is the ABA, at least, an independent voice?
Yes, and that's, I think, a direct fact bearing upon its influence. If you are an independent voice, there is no audience for you in the committee. That's the problem. There is no question in my mind, absolutely not a hint of a question in my mind, but that what the American Bar Association does is a critical, profoundly important, wonderful function with great civic virtue involved in it. Would that it would be heard. And the problem is that the last empires all of the actual or potential independent participants are shut out of the process, and that's where it begins and ends, I think.
Lee, do you agree?
I think you're just fabulous, but I pretty much disagree with everything you've said. I mean, the perception is that the ABA is not. The perception is that the ABA is not an independent voice, and that's why the Bush administration, at least one reason, took it out of the process. The Bush administration's reason for taking the ABA out of the process was that a particular group shouldn't be singled out, that there's lots of other organizations that would love to pre-screen judicial candidates, and so we shouldn't privilege the ABA. But I think there's some conventional view out there that the Bush administration was still very angry with what happened with Robert Bork. And a lot of conservatives out there, many of my conservative colleagues, are very angry about the divisive vote on Robert Bork, whom they thought was, exceptionally qualified. So whether the ABA is an independent voice or not, I don't know. But I mean, a convincing case could be made that certainly is. I don't think it's the perception. It's certainly not the perception in my world that it is, that there's sort of an ideological bias to the ABA. That said, the point I'm going to disagree with you about is I think that the qualifications of a candidate, and we've empirically demonstrated it, the qualifications of a candidate are critical to a Supreme Court nomination. I don't think Harriet Miers would have made it on the court whether the ABA said she was qualified or not, in large part because there was a perception out there that she was not qualified. And that's going to, and whoever generated that perception, and certainly, I think biased forces generate those perceptions, but that was going to filter in. And whatever we want to say about senators, they care about what we think because they want to be reelected. We're seeing that right now. So I want you to just imagine a hypothetical in which the ABA came out a split vote on Samuel Alito, qualified, and dissenting members said he was not qualified, not a unanimous, well qualified. I think that would have resonated, and the certainly biased forces, yes, would have used that information, and I'm not sure that it would have gotten through, as close as it was. So there's some tension there.
Well, Steve, that sounds like Lee doesn't necessarily think that the ABA is at least irrelevant. Why is the ABA not irrelevant?
Well,
what good are you anyway,
if
Steve?
I understand I'm not sure. If the criticism that I understand, and I've heard before today, but not as articulately as today, is that we are not independent because the ABA is the ABA, and we all know what that means. Then you have to explain to me how this ABA gave a unanimous, well-qualified rating to John Roberts, not once, but twice, gave a unanimous, well-qualified rating to Samuel A. Alito, Jr. These are the people who we are saying are not independent, but yet they come from an association that has been tagged historically as too liberal or too avant-garde or too out of touch with the mainstream of what the American people believe. I will not defend, nor do I have to defend, what the American Bar Association has accomplished over the many years that it has been around. I think it has done a lot of tremendous good, not just for the profession, but for the people we represent, which happens to be the American public. So you have to take an accordion look at what we've accomplished as a committee within that setting. And how can you say we are not independent when, in fact, we did have unanimous ratings of Samuel A. Alito, Jr. and John Roberts? And I think this is a good opportunity, if I can, to explain a little bit more about the interstitial process that nobody sees, and I can't talk a whole lot about because some of it's shrouded and behind the curtain. But the FBI does a background check on all the nominees. I can't tell you the number of people when I was the First Circuit representative and I was making calls to lawyers, judges, and non-lawyers about a nominee who would say to me, well, I wouldn't tell the FBI this, but let me tell you. Because a colleague is calling, not an FBI agent, not somebody from some other group that might have a partisan interest. A colleague is calling about the nominee and is saying to them, I need to talk to you about your involvement, your interaction with him or her. Tell me about their integrity, their professional competence, their judicial temperament. And it's defined in here. We don't stray from the field. We stick to the phrases that are well thought out, or objective phrases in this book. And we get information. This collective information comes to us and coalesces around these points. We are then able to put together an evaluation. Usually they're about 500 pages thick that nobody sees because they remain confidential with the members of the committee. The staff in Washington that works with this committee does not see them. The leadership does not see them. The chair says it's good to go. It goes out to the 14 members, and the votes come in from the various parts of the country. People don't talk to each other and say, how you voting? They read this report, and they make an independent judgment of what that person's nomination should look like to them. Well qualified, qualified, or not qualified. That's why you get mixed results. We've even had a three-way split a couple times, which was another story that we can't talk about because it's behind that curtain. So I hear what Lyle's saying, but I think Lyle's criticisms underscore all the more the very need for what the ABA is doing, that we are independent, and I believe we are extremely critical to the process. Now, let me add one thing to what Lyle says, because I agree with him in one part. We will fade in and out of relevancy as a committee all the time. We do. It's a political landscape that's constantly changing. It's a very ambulatory world out there in the judicial nomination process. And there will be times where the ABA evaluation may not mean very much to the players, the White House and the Senate Judiciary Committee, but there will be times when it will mean everything to them. And I have witnessed that compressed in the last 12 months in my experience. There is no other group out there of logical consequence that does a peer review, so that when I pick up a phone, I am talking to a colleague on the limited basis of the issues that we need to know about that individual. And we get information that no one else gets. When I testified in the Roberts matter and I testified in the Alito matter, I was asked that by Senator Sessions and by others. Isn't it true, Mr. Tober, that you get information that no one else gets? And the answer is a resounding yes, that is true. If that isn't relevant, then I don't know what is.
Let me just jump in at this point, Lisa, and say that if it had been the case that Steve's committee had been divided on Alito, if there was that one dissenting vote, the important question to ask or answer in process terms is, how would that have been received within the committee? How would it have been used? And the underlying inquiry about the role of independent voices or outside umpires is not their own integrity. It's not their own capacity to do good civic work. It is how it will be received inside a seriously infected process. And a split vote within the Senate, the ABA's Judiciary Committee would have been used by the Democrats to advance the idea that Sam Alito should not be on the Supreme Court. They would not have dwelled upon the split vote, they would have dwelled upon the dissenting vote. And they would have said, well, how could a judge ever succeed on the Supreme Court of the United States if 1/16 of the people of this country think that that judge is unqualified? You have 16 members on your committee?
15.
15. 1/15 thinks he's unqualified.
But the chair doesn't vote
Yeah.
only in case of a tie.
Okay. Jeff Sessions, on the other hand, who is one of the four most partisan members on that side of the aisle, and there are an almost equal number on the other side, Jeff Sessions, as one of the most partisan, would have said, this committee says he is qualified. Why do we need to focus on one dissenting vote? This man is qualified, and the American Bar Association says he's well qualified. And so the question is, would this independent voice, like other would-be or actual independent voices, have made a difference? or would it have been co-opted? And that's the, at least in my perception, the problem with the process as it presently exists and now functions, is that any potential independent group is going to be co-opted, and that's going to occur until such time as the process itself has been reformed, or perhaps even the whole of American politics has been reformed, so that we return to the time when we can have a political conversation that is not 4/5 venom and 1/5 rancor.
Well, even if co-opted, though, even if the voices of views of independent voices are co-opted, is there any benefit? For example, what's occurring to me is, regardless of what happens at the committee, is there a benefit in terms of public confidence? Is the ABA necessarily talking to the senators, or is there a value in having the public hear what the ABA has to say in terms of confidence in the judicial system?
Well, I mean, volunteering to answer your question, any one of the three of us could clearly answer it. I think there is a benefit in it if the ABA's voice is heard. Now, Steve can tell you better than I, because he probably has someone who monitors his press clippings. But I can tell you that the ABA's committee's report is a one-day story, unless it is a story that the nominee is not well qualified or is not qualified.
I wish that had been true.
It's a one-day story, I think,
Well,
when it's a positive qualification, because well, okay, that's the ABA's been heard from. Now, what's going to happen to the nominee? So, and the ABA, like other public institutions, private institutions with public endeavors and aspirations, depends very heavily upon the kind of media that we have in this country to get out their message. I mean, the ABA has an excellent public relations operation, but the question is, how responsive, how receptive is the general press? And if the ABA's work, deep and wonderful as it is, compelling as it is on its own merits, is not a story of continuing consequence, then one has to wonder whether it is providing a public benefit of any duration anyway.
one of the problems that we encountered was that coming into this year, when I took office in August of '05, the last time the American Bar Association was on, if you will, the national stage was 1994, the nomination of Justice Breyer. There had not been a logical platform for discussion or explanation of what our committee does until this year. And frankly, there had also not been a test of the American Bar Association since Robert Bork, because I don't think anybody perceived Justice Ginsburg or Justice Breyer to be a test of the ABA. I think they both received very fair, independent, nonpartisan evaluations, but the public didn't see it as a test. You now had this confluence of events that John Roberts, Harriet Miers, and Justice Alito were all going to be a test of the ABA. And we had the opportunity, for the first time in 11 years or 12 years, to be able to come out and explain what we do. People don't know. It is shrouded in enigma and mystery because of the way the process has unfolded. The President of the United States asked us to become involved, to keep it confidential, to keep it behind the curtain. It was like that for 40 or 50 some years, and now it's been pushed out in front. And we are dealing with the changes that has brought. But the bottom line remains, to me, and to, I think, the people who've gone through this process. I wish I could share with you, Lyle, and I really can't, the letters that we've gotten from the nominees themselves who have gone through this process. And they don't have to write me the letter or the person who evaluated them on the ground, but they found these to be the most therapeutic, effective reviews. And this isn't just because they got a WQ. Many of them didn't. They felt it was important because it was their peers speaking. They learned from it. There were times that our investigators would have to sit down with the nominee and say, well, there's some difficulties here. We need to go through A, B, and C. And they affect whatever it may have been, judicial temperament or whatever. And those nominees had to confront those issues and realize that when they go on the bench, if they haven't come to terms with those issues, they may have bigger problems. There's a whole bunch of things that go on that never saw the light of day because we do our work behind the curtain. And to say we're not relevant leaves me a little with one arm tied behind my back because I really can't talk about a lot of the things that remain confidential to this moment. I will say on a national stage, when we finally had the opportunity to address the American people and talk about what we did, I received the impression that at least for a while, we were very relevant in a political process that we choose no political side on.
Well, I can understand the nominees reacting favorably to the process because every nominee whom I've known or covered has wished that the process functions better and more objectively. And so every nominee would look at the process that your committee goes through and say, that's the way it ought to be done. It ought to be done with dignity. It ought to be done with a substantial degree perhaps of confidentiality. It ought to be done in a way that ennobles the process. But most of the modern nominees who have had any real difficulty come away from the process with years and years of resentment about it. I mean, I can tell you that Clarence Thomas to this day hurts because of what happened to him in 1991. That's 15 years ago.
But wait a minute,
Why should that matter to us?
Why
Clarence
should it
Thomas,
matter
You
to
know,
him?
Why
Well,
should it matter to us if Clarence Thomas feels that he's been maligned by the process? I mean, so when I'm listening to you, you seem to, and maybe I'm hearing it wrong,
Okay.
but you seem to be hearkening back to the days when there was a different process. The days when there were a different process, all of this was behind closed doors. The public had no idea of what was going on, and the interest groups were there, the special interests were there, the ABA was there in a different form, and we were in the dark. Now we have a process, and it was very political back then, and it was very partisan, and more nominees were turned down in the 19th century than the 20th century. We didn't know what was going on. Now we shed some light on it. And yes, I am so with you. It is all perception. It's all manipulated in lots of different ways, not necessarily, not by the ABA, but it's manipulated by lots of interest groups and so on. But it's public. We can illuminate it. And if Clarence Thomas feels maligned, or Samuel Alito, or John Roberts, you know, I think this is a good thing for democracy, not a bad thing.
let me clarify one thing about Clarence Thomas, and frankly, the only person that can tell us the truth of why he's harmed by this that he went through was Clarence Thomas. Clarence Thomas's rating was issued by the American Bar Association committee a month or two before the world heard of Anita Hill. And what happened with Anita Hill was what can happen to anybody stepping into the public domain and having to go through that process. He was found qualified by the American Bar Association. I don't think it was a systemic problem that, I'm guessing because I don't know what he thinks, but I don't think it was a systemic problem with the independent voice of the American Bar Association finding him qualified, that if it has made him so upset and angry about what he went through, scarred, I think, or harmed, I think it was the after effect of simply being in the public domain. And that, unfortunately, can happen to anybody.
Well, let me respond briefly, if I can, to what Lee suggested, because it seems not only unusual, but perhaps unseemly for a member of the press to be arguing that we need to return to a confidential process. I don't doubt but what in an earlier age, when all of this was managed behind closed doors, that it was ill-managed. I do think that there is a serious cultural problem, or at least a serious political problem, if, as a consequence of it becoming public in an age where the kind of politics that's practiced is what we are seeing now, that this does not add to the public's affection for, admiration of, and respect for the judicial process. I think the consequence of this public exhibition this carnival that it has become is itself a vice, as long as the process remains of the character that it has now adopted. And it carries on in public, in full public view, not only because of television, but also because of all the other new media as well. And it is another exhibition of how our politics just doesn't work, even closely to the way that most Americans would like it to work. And so, okay, as a media member, I am arguing in favor of maybe perhaps toning down the nature of the media coverage of it, or maybe changing the way the media perceives it, so that the media once again starts paying attention to process rather than outcome. And if a judicial nomination is perceived by a media that is only looking to who wins at the end of the process, then all of that important stuff that goes on before the final vote is cast is ignored. And it's now all of that process that goes on before the vote is cast that is so infected. And putting it on public display, it seems to me, Lee, doesn't help it.
Well, how does it hurt?
Well, I think it contributes to what at least everybody in the judiciary that I talk to regards as an enormous, now pervasive threat to judicial independence.
But you know better than I do, because you've been around a long time reporting on the court, that these things come up. Look at the 50s. They came up in the 1800s, well before we had a very politicized process. We've had periodic attacks on the independence of the judiciary. So I don't know. I mean, maybe you're right, but it seems tenuous to me.
Well, when I talk to justices and judges, federal judges in particular, the number one concern they have these days is judicial independence. I mean, Sandra Day O'Connor is devoting her retirement to the defense of the independence of the judiciary. And judge after judge will cite to you the example of the federal judge in Chicago, 3 of whose family members were assassinated by a disgruntled litigant. And it was after that episode that a member of the Senate Judiciary Committee said, well, this is what happens when you have judges making decisions that offend people as deeply as this does. My God, where have we come to? If we've gotten to the place where a judge can be threatened personally or have their families actually assassinated because of the substance of a decision they made. And I think the way the judicial nomination process works right now, with people like John Cornyn sitting there, and he's the one who made the remark about the Chicago judge's family. With people like that carrying on this process in the way that they do carry it on, it seems to me contributes to a perception that, by God, we got to do something about these independent judges. We have got to take away their power. And so now you see we've just had the passage of the first suspension of the writ of habeas corpus since the Civil War. We've also seen the first recent example of stripping the federal courts of their jurisdiction. Lee, I don't think these are separated, isolated events. I think this is all a part of a cultural shift that we are moving towards a place where we do not trust judges to make independent, objective judgments, and the Senate judiciary process is a major factor in that.
But the question I would ask you is that an implication of the process, or is it in fact because of decisions courts reach? I mean, does court stripping come about because, hey, Congress is afraid that this court is going to make a decision it's not going to like? So that it ties less to, I mean, when I hear about judicial independence and I listen to what Sandra Day O'Connor's saying, she's talking about attacks on judges largely as a result of decisions they've reached. Or do you think that I'm trying to figure out what that link is between these clearly politicized nomination proceedings and judicial independence, or is it about decisions?
No, I think that the The ultimate question for federal judges now is, do we have to curtail the substantive nature of our opinions in order to satisfy our political auditors? And the political auditors are now more aggressively pursuing the substantive legal decisions, partly because this is what they're hearing from their constituents. I mean, we've all talked about, and I remember sitting up late at night covering the case as it unfolded, the case involving Terry Schiavo. And Terry Schiavo's, the episode, however tragic it was for the family, was an ultimate test of whether the judiciary of this country can undertake day in and day out, night in and night out, to make a thoroughgoing inquiry into the substance of the law and then call it as the law says that it should be, or whether or not they're going to lose that power to do it. And how many pieces of legislation did you see introduced that would take away from Judge Greer the opportunity to make that decision? And I think the Judiciary Committee process energizes that kind of political clout. I mean, what makes Jim Sensenbrenner, the chairman of the Senate Judiciary Committee, behave the way he does toward the Senate Judiciary now? It's because he's hearing it from home, and he's hearing it from people who have watched the Senate Judiciary Committee and said, you're damn right to go after them on their philosophy, because that's what it's all about.
Well, let's talk about that for a minute, because, and I want to lead us into a discussion. I want to ask if any of the panelists agree with the quote that I began with, that even participation, vocal and vigorous participation by partisan interest groups is beneficial to the process. But before we get to that, let's step back and I'd like your views on what should count in terms of a judicial nominee. You know, Lee, you said that it's always has been political, and certainly, you know, even I am familiar with the sort of political tit for tat that's been gone on since the very birth of the Republic in terms of I don't get what I want, you're not getting what you want either. But in terms of a judge's political viewpoints as fair game, is that new or is that not new? And should it count? Do we even know what the framers intended to have count? You know, what's fair game?
Well, I wasn't around during the founding, despite everybody's perception that they have been. I would have loved to have been. I think a judge's philosophy is absolutely fair game. It certainly is a cardinal factor in the president's initial selection these days. I mean, one would like to go back to the days when Gerald Ford picked John Paul Stevens for the court on the basis of merit. John Paul Stevens didn't have any political clout to speak of. John Paul Stevens was just an excellent judge, and Gerald Ford, or the process that led to his nomination, was capable of seeing that. And I don't think we're likely to return to that process, but I do believe that a fair inquiry into judicial philosophy, and this is something the Steve's committee probably not only doesn't do, but shouldn't do. I know they don't do that. They shouldn't do it because, at least in the present environment, if they were beginning to audit judicial philosophy, then that would only contribute further to the nature of the process. But I do believe that what a judge thinks, what a judge's perception of what the law is, a judge's view of stare decisis, all of the issues that you hear over and over again in nomination hearings, you wish that the inquiry were more serious than it often is. But those are things I think people are entitled to know. And from my sense, I think it was probably always that way, wasn't it? I mean, from the beginning, justices were picked sometimes because they were close family members, but sometimes, most of the time, most presidents, I think, have not shied away from staffing the branches with people they think would vote the right way.
Oh, yeah. I mean, I think this connection, and I'm only really going to talk about the Supreme Court, this connection between, you know, what are the ideological commitments, the partisan commitments that these nominees have, and it's certainly reflected in their votes. I mean, the political science party line, you know, on the Supreme Court, we can do a pretty good job in predicting votes based on the ideology of these justices. And if it's going to matter for their decisions, then it should matter up front. It's something we should be able to inquire and ask about.
Let me turn back to the question you asked for a moment, because the reason, and I wasn't there either, Lyle, but the reason that President Eisenhower asked us to come inside the tent was because he wanted to depoliticize the process. There's no question that, forget us for the moment, the ABA, the process is a series of tectonic plates of politics exploding against each other whenever there's a political change in the White House or in the Senate or both, and whenever there happens to be coming along a vacancy on some high-profile court. And I agree, the Court of Appeals and the Supreme Court are of very great interest to an awful lot of groups, and district courts too, but to a lesser degree. And we've never changed our role from what President Eisenhower asked us to do. My understanding was, he said, look, I'm tired of the competing forces of politics that these senators are giving me as to who should get these seats. I'd like to have a nonpartisan voice tell me what they think are professional qualifications. We've never changed from that. We still do that. We sort of free float in the river of politics that clashes, when it clashes, between the White House and the Congress. And that brings me back to your point. If there are other interest groups that want to be involved, there is nothing stopping them at this moment from being involved. They have every opportunity to lobby the White House, to lobby Congress, to work any level of media interest they wish to work. There is nothing stopping partisan interest from being involved. In fact, Lyle mentioned his experience with folks in Washington who are well known and who are very active in the judicial selection process. The independent voice of the American Bar Association remains unique when you get to the bottom line, because of who we are and what we try to bring to the process, and because we've spent 50 or 60 years honing down the standards and the process itself to meet what we started out with for our original charge. There may be other groups out there, but in my experience, and it's limited, every one of them has a partisan interest. And our only interest has been all along the quality of the third branch of government. And that's what we continue to deliver. So I think it's worth revisiting why we even started doing this. Because when I became a student of this committee, one of the first charges I had was keep it on the same line.
So you're saying, in a sense, was the independent voice of the ABA, the nonpartisan, non-ideological voice that was really new on the scene. If it's been always been political, if presidents have always been picking nominees based on politics, that if anything's changed is a careful look at qualifications. And
there's no question that when the framers wrote the Constitution and the Federalist Papers were created, Federalist 78 in particular, and they talked about the balance they wanted to have here, there's no question it came out of a political process, and it was meant to be a political co-equal tension that kept the thing moving forward. There's a great book I read years ago called The Machine That Would Go of Itself. And I think that's still probably one of the best books I've ever read about the vitality of the Constitution. And that's that process. Now, we emerged in 1948 and then again in 1952 at the request of the leadership in Washington to try to come in as lawyers and judges and look at integrity, professional competence, judicial temperament, and report back to the White House, back then before the nomination, now after the nomination, on what we find. I don't know of any other organization that has the resources or the ability or the history to do that than the American Bar Association.
okay, well, perhaps not professional qualifications, but what about this notion of greater participation of interest groups? Is the process served? Or is the American public served? Is the judiciary served by vigorous participation of interest groups? And another question that's related to this is, Steve said nothing's stopping interest groups from participating, but isn't it the case that the level of participation of interest groups varies with the structure or the composition of and the leadership of the Senate Judiciary Committee? Does the committee perhaps have too much authority over the structure of hearings, the scheduling of hearings, the time, who gets what time, who gets to submit what? So that's a lot of questions.
Well, the Judiciary Committee in this respect isn't different from any other committee. It is run by the majority and is primarily run by the chairman. The chairman depending upon who it is, I mean, when Jim Eastland was the chairman of the committee, you could expect that most of his choices were unfair about how he ran the process. But Orrin Hatch ran the committee in a reasonably fair way. I think Arlen Specter runs it in a quite fair way. But I think what's different, and I suppose I could be understood to be harping on this, I think what's different is that however the committee is managed, the influences upon that committee have been reduced in number. The influential outside participation in that process has been reduced in number so greatly that the prospect for other independent voices coming in and having an influence, having an impact, is much diminished. And that's because it takes an enormous amount of money for somebody like the People for the American Way or Boyd and Gray's. But it takes an enormous amount of money to develop a grassroots organization, to prepare all of the documentary material they do, the advertisements. That is a huge undertaking financially. And only a few groups are capable of doing that. I think, for example, back in the days in politics, when voters always looked to the League of Women Voters for guidance on how we should vote when election day come. Everybody trusted the League of American Voters, the League of American Women Voters. Yes, that my wife reminds me of the gender-specific nature of that group. Everybody trusted what they said. The reality is that those organizations that now have the primary influence, very rich organizations, enormously capable of raising money and propagating their message, have crowded everybody else out of the field because everybody else cannot do it. And then when Boyd and Gray and the White House decide to set up an alternative organization, they do it by the same way. They gather huge sums of money, and they get very committed people, and they do elbow their way in. Now, they elbow their way in and are accepted in the process because they facilitate one or the other sides in the controversy, and the controversy is always that divided. So it is, I think it would be wonderful if an organization like the League of Women Voters, let's say the American Academy for Independent Justice or something like that, should come into being and have a part on it. But how soon would they be able to do so? And once they were able to do so, would they be able independently and individually to reform the process? That's a pretty large undertaking when the process has gone off the rails as far as it has.
Lee, do you think there should be, that this participation is valuable, even by heavily partisan organizations? And if so, do you agree with Lyle that there aren't enough voices being heard?
You know, it is what it is. You know, I'm sort of a political realist here. Again, as long as, I mean, and we can even trace the development and when this all started, and really so much of it traces back to the Warren Court, traces back to Brown. You know, when there's a perception that the court's political, the political people are going to come out. Is it dominated by particular sets of interests? Sure, now they've formed these coalitions, groups within groups within groups, and they have a lot of money to shape our perceptions of these candidates. Does it, at the end of the day, sort of resemble a jury trial? You know, with both, you know, neither side, of course, wants the truth. They want to win. And so, you know, both sides are out there doing the best they can to shape our perceptions of the qualifications of the candidate, of the ideology of the candidate. And, you know, maybe at some point that's the truth does emerge from that process. I don't know. But, you know, as this isn't going to go away. Unless all of a sudden the Supreme Court of the United States becomes a very apolitical body, and in fact Scalia and Stevens become fungible, this isn't going to stop. I would say one other thing too. I think the role of the Judiciary Committee really is a lot more important at the lower court levels, and as especially the Court of Appeals, the various norms that are in the Senate, senatorial courtesy at the district court level, and how chairs of that committee interpret some of those norms has been important in recent years. But
I just want to say, I don't know where the system came off the rails. I must have missed that memo.
yeah,
Do you think it is off the rails or not?
Well, Lyle just said he thinks it's off the rails. And I don't mean to misquote Lyle. He can say again what he meant. That's where lifetime tenure comes in. We sometimes get judges who change their posture on a lot of things when they get onto the federal bench. That's no news. And it's not my bailiwick. I'm here to talk about process. But I don't see the system coming off the rails. I do see a lot more attacks in the media on activist judges. I have seen from my own experience in New Hampshire, where I represented a justice on our Supreme Court in an impeachment crisis, the canary in the mine matter up in New Hampshire 6 years ago, that's probably going to happen in other states when legislators don't like decisions. But that's been with us from the beginning. And the process works. We've had impeachments, and we've had survival from impeachments. So I don't know, at the end of the day, where we think it's come off the rails, whether the Senate Judiciary Committee has overstated its advice and consent authority, whether the president or any president is attempting to follow a political agenda to a point where it may harm interests. It hasn't happened yet. It may, but I think history is pretty full with examples of people who went on the court who we thought we knew, but in fact came out a little different. And one of them happens to be from New Hampshire, I suspect.
Well, I think the Supreme Court of the United States has tremendous curative powers as an institution over whatever wounds or injuries are brought into the place from the Senate confirmation process. I mean, the way that the Supreme Court works, at least the way it worked under Bill Rehnquist, and the way that I perceive it is now beginning to work under John Roberts, is an institution that is quite capable of building community, a sense of personal caring about each other. I mean, Bill Rehnquist ran the happiest court in all of the 50 years that I've been covering, 50 plus years that I've been covering it. And so to a very substantial degree, that process was helping Clarence Thomas become an independent judge and to try as best he could to overcome the wounds that he suffered. Sam Alito will probably be embraced in the same way that Clarence was, and will do that. Whether or not they change in ideological orientation depends, I think, very much on the dynamic of the process and the substantive nature of the issues that come before the court. I mean, if you had sat in on the nomination hearings for Tony Kennedy for the Supreme Court of the United States, would you have ever imagined that Tony would write the most sweeping liberation of gay people that has been known in our constitutional history, Lawrence against Texas? Would you have imagined that Tony Kennedy would have written Lee against Weissman on the prayers at public school ceremonies? There is a process within the court where judges, I don't like to say grow because people say, you say he grows only when he starts agreeing with your point of view, but where a judge does begin to see the issues in somewhat different ways and starts voting and writing differently. So I do think that the Supreme Court can cure some of the defects of this. The question is not so much how well the court functions after one of these bruising battles, but the question is what happens across the street in the political branches where these bruising battles simply feed more of the sense, that this is ours to win and yours to lose. And by the way, I think in partial response to something that Lee said earlier, I have watched various interest groups involved in the confirmation process try to make an issue of the future of the Supreme Court in presidential campaigns, and it never flies as an issue. I mean, you do surveys at the polls, you do public opinion surveys, and never does anybody say, in 2000 when George Bush was running, never does anybody say, on the outcome of this election rides the future of the Supreme Court of the United States. You didn't hear that in 2004, though the interest groups were trying to sell it. So One of the problems that we may be dealing with here is monumental public indifference to the process. And so Lee says it's going on out in the open, but aside from seeing what it actually is, the show trial that it does become when it involves a Supreme Court nomination, is anybody paying attention? Is anybody listening? And I'm not so sure that people are listening, at least to the degree that they will actually cast their vote in a presidential election when the future of the Supreme Court is on the line. And the future of the Supreme Court has been on the line in every presidential election since Bob Bork was nominated to replace Lewis Powell. The court has been that closely divided. And so every Supreme Court nomination that's come up has been, this is what the future of the court is all about. And the stakes are enormous. And that's partly why everybody in the political realm is so interested. But why isn't the public interested? It baffles me.
Well, on the other hand, though, after Clarence Thomas's nomination, several senators lost their seats. I mean, Weiss Fowler in Georgia probably lost that election because of his vote in favor of Clarence Thomas. So, the voters are maybe responding where it really matters, which is the Senate, not as much the president. Where they can't really handcuff the president as much.
But then you always have the example that Oklahoma has given us Tom Coburn, which is a really tragic commentary on the politics of Oklahoma.
Let's talk a little bit about the media, if we could. I began with the quote that suggested that there's at least one view that sort of hard-driving partisan interest group participation in the process is beneficial. We get to see all the potential warts, and we get to see, both sides. We get to see, really get to know the nominee. The media, Lee talked about at the beginning of her remarks about the value of the media portrayals of nominees. It would seem to me that of all the things that we might be able to change, the Judiciary Committee process, formalizing that, whatever, the media would seem to me to be one thing that we can't change, and I don't think necessarily would want to change. I mean, that in terms of its freedoms under the First Amendment. Are there, however, costs to the system of the current sort of version of media coverage that we get, the saturation coverage, the fact that the media, or the risk perhaps that the vagaries of various media imperatives in terms of competition with other big news, is it a slow news day or not, the relative sexiness of the story, that those unduly affect the outcomes, that they skew the actual outcome. That's just one possible risk that occurs to me. What are your takes on the media, the good, bad, and the ugly? And what, if anything, can be done or should be done?
Let me start, and I certainly don't want to dominate this part of the discussion either. Look back at how the media responded to Steve Breyer's nomination. The media lost interest in Steve Breyer after the first day of the committee hearings because it was a non-controversial nomination. When Strom Thurmond embraces Steve Breyer wholeheartedly, that sends a message to everybody on the Republican side of the committee: this fight is over. So the media dropped Steve Breyer after day one. You could see it in the committee room. The first day Breyer comes in and testifies, the entire media tables, and there are usually 4 or 5 tables with about 15 or 20 people at each. The first day of the hearings, everybody was there. The second day of the hearings, the old Hardys were there, the wire services, and a few of the major newspapers and people like that. The media lost interest in it because it was devoid of controversy. Now, the media loves, at least the Washington media, loves nothing so much as it loves a fight. And so the Senate Judiciary Committee functioning the way it does now is a wonderful thing to cover media-wise. And so how are you going to reform that? Now, the question is, you could reform it if every president picked nominees who were non-controversial. And, Bill Clinton was was pretty nearly successful in picking both Ruth Ginsburg and Steve Breyer and essentially neutralizing the opposition. Neither one of them had any difficulty getting through that committee. And as a matter of fact, neither did somebody like Tony Kennedy. A lot of nominees have gotten through without controversy, but not with the ongoing, active, intense attention of the press. Because once the horse race outcome is clear, the media stops paying attention. And maybe that's the point at which, you know, we need to say to you guys, why do you only want to cover it when it's a nasty fight? Why don't you cover process? But that's true of the media covering the White House. That's true of the media covering the courts. It's true of the media covering, watch the media coverage tomorrow morning after the conclusion of the National League Championship Series. How much of it will be about really the substantive nature of baseball, and how much of it will be purely oriented towards outcome?
Well, that's where the last umpires really are.
That's where the last umpires really are. Yeah.
Other thoughts on the media? Its value or harm to the system?
I would only say, partly it's the political conditions that cause the controversy too. I mean, Ruth Bader Ginsburg came up with a Democratic Senate, a Democratic president. There was no way she was going to there was nothing, that was going to bring her down. Ruth Bader Ginsburg with a 60-person Republican Senate, that nomination starts to look a lot different. She would have been absolutely grilled about abortion, the Equal Rights Amendment, in ways that weren't controversial then, because of the political conditions. So there's this interaction, I think, there that we shouldn't necessarily ignore either.
Allow me an observation, because I don't really want to pass judgment on this, but, and I bet Lee probably has the data on this. Historically, the hearings for Supreme Court nominees going back for Ginsburg and Breyer were pretty short affairs. Mm-hmm. They would last a day or two. Some of them lasted minutes.
That's right.
And what we now have are hearings that last, for the nominee, 4 to 5 days, mm-hmm. and then the collateral witnesses, and as I recall, in both Roberts and Alito, there were 31 witnesses, mm-hmm. The ABA, and then they had a proportionate distribution of additional witnesses, which went on for another day and a half. I take that to be a product of the media. As long as there's interest in coverage, that you will have an attenuated, extended hearing. And is that good or bad? I leave that for the judgment of others. The other point that we talked about today in front of the first-year law students is the impact of the internet, and of cable. You have expanded the technology, and now we've expanded the effort to use it. And whether or not that's good or bad, I guess, is to be looked at probably in 20 years when we have the perspective to look back at it.
Well, I think we already have one very good case study, because I think the conservative blogosphere was extremely efficient and successful in killing the Harriet Miers nomination. The conservative political community was very suspicious of Harriet because they thought she was insufficiently dependable ideologically. They suffered some pain about the opposition because they didn't want to go against George Bush's wishes. But the blogosphere, the conservative blogosphere, is what ultimately was successful in bringing her down. And they made enough noise, they did enough to really to literally destroy her reputation, I think, such as it was. Maybe it didn't need a whole lot of negative response to make it as unattractive as it turned out ultimately to be. But I think the blogosphere made a real difference in killing that nomination. I think it would have died ultimately on its own lack of weight, if you will. But I think it was hastened by the media, the new media, with particularly the emphasis on the conservative blogosphere.
It's a good time, I think, unless the panelists have anything else they want to add right now, to invite our audience members to ask questions or comments, argue with the panelists, argue with me, although I don't think I've said anything very controversial. So, any questions?
In part, I want to ask the first question to tell you if you want to ask questions, come to a microphone. But my question is about the role of actually judges testifying in judicial confirmation hearings. This happened in the Alito case where he had a number of his colleagues come forward. They were part of these supplementary witnesses that Steve Tober referred to. Presumably, these judges themselves are independent voices. Do you think that that was a good thing, a bad thing, or, to use Lyle Dennison's alternative, irrelevant thing to have judges come forward and speak on behalf of nominees, sitting judges who are insulated, presumably, at least so long as they don't aspire to a higher office on the bench, from any kind of repercussions? Is there a role for judges themselves to testify or participate in the federal confirmation process?
Well, and certainly when Judge Alito's colleagues on the Third Circuit came down en masse to speak up for his nomination, a lot of eyebrows were raised. And I think those whose eyebrows were raised for objective reasons were upset to see the judges get drawn into the process. They were made pawns of the Republican campaign to get Sam Alito confirmed. If the audience that heard them out was an audience that was capable of hearing what they said substantively about him, rather than hearing it through the filter of, are these guys for or against Sam Alito, it probably would have been a more civically useful thing to do. The colleagues of a nominee can have a very important perspective. I mean, and Steve's committee proves this over and over again. But I'm familiar with an experience where a colleague killed a nomination. You may remember when first President Ford was faced with the selection of a replacement for, it was Bill Brennan, wasn't it, when he picked David Souter. President Ford had 3 nominees recommended to him by his staff. One was David Souter, one was Edith Jones on the Fifth Circuit, and one was Larry Silberman from the D.C. Circuit. Bush himself vetoed Larry Silberman because they had had a tiff when Bush was ambassador to the UN. John Sununu, who was then his chief of staff, was very high on David Souter, so was pushing for him. And in fact, we all remember, told the president he will be a home run for conservatives, which of course turned out not to be true. But Edith Jones' nomination was absolutely defeated. President George H.W. Bush wanted her to be the nominee. She had been the counsel for the Republican Party in Texas. She was very close to the Bush family and particularly to first President Bush. But 2 of her colleagues on the Fifth Circuit notified the chairman of the Judiciary Committee that if she were nominated, they would come and publicly oppose her nomination for ethical reasons because of her behavior on the bench. So that it's obvious that judges who serve with a colleague can have a very major influence on it, particularly if it's a negative influence. But in the case of the 3 judges who appeared, the 4 judges, I guess it was, from the Third Circuit, I don't think they added that much, and I do think people were wondering, well, what are you doing here? Are you just a pawn of the process?
And that is an advertisement for why the American Bar Association should do pre-nomination screening, because that's the kind of embarrassment that can be avoided by an effective informal report back to the White House or the Department of Justice about what colleagues and others are saying about a particular nominee. And we don't have the data. I was telling that to Lee. We simply don't have the collective business records, and if we did, I couldn't share them anyway because they're confidential. But the number of times that reports went back, anecdotally, were significant, where there was a problem. And the President of the United States had to make a decision about whether or not to proceed with a political issue and a potential embarrassment for the individual or find somebody else. And to the rest of the world, it was seamless. That's an example of it.
I think something Lyle said was very important, that the reason those judges were there were to shore up the Republicans on the committee. And what are those judges doing? They're speaking to the integrity, the temperament of Alito. And the fact that the Republicans on the committee thought this would be a good idea speaks, I think, to the notion about qualifications, not objective qualifications, but the perception that this person has the temperament to sit on the Supreme Court. And so the fact that the Republicans wanted these guys there, I think suggests something that the qualifications is not irrelevant, or at least the perception of qualifications. How you develop that, I don't know.
I remember a testimony offered by a previous chair of the American Bar Association Standing Committee for a Supreme Court nominee, and I remember reading it in preparation for my having to do my own, and I was startled to see a question. I think it was from Chairman Thurman, and the question was something like, did you talk to the other Supreme Court justices? Do they like this person? And the chair said, yes, we did, and they like him. And I thought that was a remarkable piece of comment that suddenly was in the record. But somehow or other, that stuff sometimes gets out there anyway.
Just for what it's worth, speaking as sort of a, you know, an educated participant in the process, but just my reaction as a citizen when the judges showed up. I mean, I was both sort of, you know, comforted that these judges thought he would do a good job and was a good judge. And at the same time, I was horrified that Third Circuit judges were there. It made me want to go take a shower in some ways, because it just seemed, you know, you could see that in some ways that they were being used. And, you know, the whole tension about whether the more judges say in public about anything, to what extent that diminishes public confidence and those kinds of issues. But anyway, I thought it was a remarkable moment, to say the least.
But Lee, of course, I mean, in the whole inquiry that you raise in this panel, should independent voices be heard? And it's hard to imagine more independent voices than sitting judges who, you know, even though they like the fellow, you can't imagine any of them getting up there and sticking their neck out if they didn't think he was
That was sort of the
capable
comforting
doing the
part,
job.
right?
I mean, that had to be comforting, and that was an independent voice. And again, I'm riding my same horse. The problem was, how did they get used?
Other questions or comments?
First, I want to thank the panelists for coming here and for a fascinating conversation. I look forward to sending the link to this archived discussion to the many people who were scared away by the rain. I hope, Lyle, I hope you link to it too from SCOTUS blog, because you have a lot of readers. The question is, if the media are in fact focused so exclusively on winners and losers, and I think there are some notable exceptions in the recent nomination battles. But if they are overly fascinated by how the vote's going to come out, and not so much on the process or the substance, what's stopping them? Is it a perception that there's no interest in this? Is it because they're lazy and they're just being steered by the partisan players? What is stopping them?
Well, I mean, growing up in the news business, you can't help yourself, you know, because you confront a situation where everybody's agreeable, and that's just not a story. You know, you're not in the habit of thinking we're going to write good news. You're in the habit in journalism, American journalism, you're in the habit of looking for controversy. I mean, why does the press do as good a job as it does in the role of, you know, of watchdog, and it does an excellent job of that? It's because it's looking for something that's really a stirring kind of a fight. And I mean, you can give lots of examples. Clarence Thomas's nomination was of little interest to the press after the first day or two of controversy over whether or not he was the most qualified person in the country, as President H.W. Bush said he was. But the minute the scandal broke, when Nina Totenberg broke the story about the mistreatment of women by him, the Anita Hill case, the press was back in droves. I mean, I remember being on a panel show the morning before that broke, on CNN, and we were talking about, would anybody vote against Clarence Thomas? And at that point, the press had totally lost interest. But stir some controversy back into it, and they will return in droves. And I think it's an occupational hazard, or an occupational vice, if you will. It's very hard to sell newspapers, or to attract television or cable viewers, if you're only giving people good news that makes them feel better. I mean, the American media is changing enough now that we're trying hard to get people more things that make them feel better, because we think of people now not so much as readers as consumers. But it seems to me there is an institutional bias in the American media, particularly in newspapering, who probably alone have the technological capacity to look in depth. Because we don't expect cable to look in depth. We don't expect commercial network television to look in depth. And a lot of the times these days we don't expect the blogosphere to look in depth. But the newspapers are capable of doing that. And your question is really an ultimate, very serious one. Why don't they? The media is not fascinated by process unless it's a dogfight.
Your question also raises another provocative point, and that is there an area of privacy that a judicial nominee is entitled to that need not be out there because it doesn't affect his or her qualifications to serve on the bench? Integrity, professional competence, and judicial temperament are what we do. I think that leaves an area of private concerns that people are entitled to continue to treat private. And historically, that used to be the case. But the media has approached it in a different fashion, I think in more modern times, so that nothing is private anymore. I won't pass comment on the Anita Hill controversy. That probably was something that affected the professional qualifications of that individual. But there are areas out there of private activity that people are entitled to do in the four corners of their home that do not affect their integrity, do not affect their professional competence, and do not affect their judicial temperament. And why are we making those the issues? Justice Alito spoke to the Nassau County group of lawyers and judges this month and told the story about how the Boston Globe went out and hired a genealogist because there had been an issue raised in a blog about whether or not his father truly was from Italy. And he went on to say he found that to be a very dangerous and damning thing to do because it was challenging his reputation, his good name. He could not understand for the life of him why that was an important issue. And I think there's a piece of all of us that can probably understand that too. So there's a question for another day. Is there some penumbral privacy that should not be part of the process when we evaluate federal judicial nominees?
It's very hard to sort out. I mean, to me, in terms of judging, lots of things come into play. It's not just whether somebody has integrity or the right temperament, but their philosophy, their background, their ideological commitments, and how do we draw the line on what is relevant and what is not relevant? Is someone's sexual orientation relevant? Is that just in the four corners of their house, or is that going to have a role and influence their judging? Those lines seem to me really tough. Now, maybe the Italian genealogy thing crosses it, but it's tough.
Well, but I mean, you have to ask the question, why did the Boston Globe do that?
That's right.
And the answer probably is that somebody said, look, this may affect the outcome. Somebody may make an issue of this. A question has been raised about his ancestry. It's going to come into the hearings. So let's go find out before it comes up. And, the American media, whatever other vices they have, they do not lack the capacity to pursue things to the ends of the earth now. I mean, investigative journalism is as good as it has ever been. I mean, Lincoln Steffens would be embarrassed about how poor his techniques were if he were to watch the unfolding of a modern news investigative story now.
That's
And
a good thing, no?
Well, it's a very good thing, but the question becomes, and I think Steve has raised the proper question, if you're talking about a public process in which the media is a major player, are there no limits? And assuming for the sake of the argument, objectively, that there should be limits, how do we define those limits? Who defines them, and how do they get enforced? And it's one thing to say that the media should be stopped from doing this kind of thing, but then the next thing is he says, okay, walk up to the plate with a solution for it. And sometimes the Supreme Court knows itself that the only restraint that we have upon us is self-restraint. And sometimes maybe that's the same thing with the media. But how do you persuade them that that's out of bounds? As Lee points out, from her perspective, it might not have been out of bounds. It might have been out of bounds. But from my perspective, watching the process, the Boston Globe very likely thought not only is it in bounds, but it's going to affect the process. And I can understand, thoroughly understand, why Sam Alito was unhappy with it. Because, first of all, and I heard him discuss the same thing in Colorado. First of all, he was offended that anybody should doubt his word. Second, he thought it was an intrusion into his family's privacy. And third, he thought it was profoundly beside the point. So what does this have to do with my capacity to sit on the Supreme Court? But it's probably a very good example of whether or not the media even thinks about self-restraint when it comes to one of these processes. And the media is no different than anybody else. They would like to think they had an influence over it. Because there are, in journalism, prizes looming out there for people who make a difference on public policy. I mean, the Pulitzer itself is a prize that is almost exclusively given to people who can demonstrate an influence on public policy. And I know a guy who won a Pulitzer Prize because he influenced the Supreme Court nomination. He's the guy who kept Clement Haynsworth from serving on the Supreme Court of the United States by bringing out the background of some of Clement family investments. I mean, there are people who knew and loved Clement Haynsworth, and they would tell you he would have been a fine Supreme Court justice. But Clement Haynsworth didn't have a chance once the Chicago Daily News went after him on his investments or his family's investments and the cases on which he sat. And that was the first time, to my knowledge, that family investments became, or personal investments became an issue in a nomination hearing. Now it comes up all the time.
Every time.
Sam Alito had to live with it, through the Vanguard system, that, the episodes involving his sister's role as an attorney for Vanguard. And he resents that too. He still resents that. But the question is, why do we do it now? Well, we did it and it made a difference when Clem Haynsworth was up there, so why not do it now?
But the public's the big beneficiary, I think. The media may be doing it to influence the process, but why shouldn't the public have this information? This is the only time we have to scrutinize these people. They're on the bench for life.
Judge Alper, you have a question? We have time for one more question.
It's actually a question for the media, so Steve, you can relax. It really jumps in on what Lee just said, and that is, I agree it's the one time the public gets to have all this information, but it's the nature of some of this information that may not be relevant, like the Alito's Italian descent. And it's the way in which it comes out there, the way in which not only the senators are asking the questions, but it's not just what's going on, because most people aren't watching C-SPAN coverage. They're watching, CNN or Fox or MSNBC, and you got the two talking heads, and they're saying all these things about the nominee, and in the way they're attacking the nominee. To me, what I see there is not a public that's more educated. I see a court, and the one that's supposed to be the great institution there, shrouded still in mystery, but I see the court brought down to a level that loses or causes it to lose respect of the people. That's my biggest concern about this amount of coverage, is that when you see these folks attacked, well, so everybody who doesn't like Clarence Thomas can write off the Supreme Court because he's sitting on it, or people who don't like Alito, and does it then cause the public, and if the public needs to have confidence in any institution, it needs to have confidence in the judiciary, but most notably the Supreme Court, does it almost take these figures and humanize them to the point where they're not respected? That's my concern of what the media is doing by all this, not just by the coverage, but by the commentary that goes hand in hand with the coverage in the 24-hour news cycle. Is that causing a diminution of the institution that's going to be to the detriment of the long-term constitutional system that we have?
Well, I fear, Judge, that the answer to your question is yes. I mean, there isn't a public endeavor or activity, however noble it is, that the press cannot turn into the profane. I mean, that's a capacity that we have. And an institution as august as the Supreme Court of the United States, I think these days, frankly, is at risk of being profaned by this process. I mean, what does profane mean? Putting outside the pale. And whenever this process is on exhibition in the style that it has now chosen to adopt, and I think this is a willing choice. This is not an unintended consequence of the change in politics. This is an affirmatively, aggressively embraced mode of doing public business. And I think that is causing, I believe it will continue to cause, a serious erosion of public support in the judiciary. And once more, I return to looking at all of those legislative packages that keep popping up about how we're going to punish the judges for being judges and doing what judges do, and what judges do better than anybody. So I think the answer, there are serious questions, Lisa. There are really profoundly serious questions about the role of the media, not simply in covering the judicial process, but in covering public affairs generally. And you know, I hang around a place where you would expect that most of the reporters who come into the Supreme Court and sit down to cover a case would be people who had spent some time thinking about it, who would be students of the process and of the institution. But I encounter people coming in. I mean, during the Terry Schiavo case, the press room of the court was overrun by these sniveling adolescents who came in from various places around the country, and all they cared about was the media glory of the Terry Schiavo case. They couldn't care less about the process. They couldn't care less about the nature of judging. The same thing happened during Bush versus Gore. I mean, being around the Supreme Court of the United States during Bush versus Gore was like being either in an armed camp or on somewhere along the Mexican border where the Klieg lights are up and the machine guns are at the ready and so on. This was an institution that was totally incapable of functioning as it normally functions, in a quiet, restrained way, because it was the center of a media maelstrom. I mean, Tony Kennedy, to this day, will tell you how unhappy he was that he couldn't drive in and out of the garage of the Supreme Court without being filmed for television. Yeah. And so, again, once more, my theme, there are serious problems with the way the media addresses public affairs in serious public institutions. Something needs to be done about it. Hang them all.
Well, at least as we will see when Congress takes steps to take, for example, a jurisdiction stripping test, the court's going to get the last word on that one, and probably very, very soon with respect to the habeas. Well, it's past 6 o'clock. I want to thank all of you very much for coming, for your gracious attention, for your thoughtful participation. And would you please join me in thanking our distinguished panelists for sharing their knowledge and viewpoints with us today.
Good evening.